Yes.
Hello. Uh,
Please introduce yourself.
so, uh, Good afternoon, sir.
Please introduce yourself.
Sir, my name is Anshuman Rath. I am from Rourkela. I completed my schooling from Chinmay Vidyalaya English Medium School in the year of 2012 as the 10th and plus 2 in 2024 in the same school itself. Then I completed my graduation, that is BA LLB honors from National Law University, Odisha, and also I did my LLM from National Law University, Odisha from Constitutional Law as a specialization. Then I am doing my PhD, currently doing my PhD from SUA National Institute of Law, and simultaneously I am working in SUA National Institute of Law as an assistant professor, sir.
Okay. What is the doctrine of this basic structure as laid down as by the Honorable Supreme Court of India?
Sir, doctrine of basic structure is given in the case of Keshwananda Bharti versus state of Kerala, where exactly it is said that Parliament can make any type of amendment as per its choice, but it cannot hamper the basic structure doctrine. But as per the definition of basic structure doctrine is concerned, the basic structure doctrine is not defined in anywhere, because if we define basic structure doctrine, we are limiting its power through its definition. So, not to limit its power, the basic structure doctrine is not defined, but it is the basic principle upon which the constitution is standing, or it is the building blocks of the constitution or pillars of the constitution to which this constitution is standing as of date.
Whether judicial review is a basic structure of the Constitution?
As per Article 13(2), judicial review is the basic structure of the Constitution, because judicial review is only could check the fair and reasonable aspect of the legislature. If a legislator is framing the law, whether that law is fair and reasonable or not, it is the power of the judicial review to rectify,
What is
to
the
check.
leading case in the matter? What is the leading case in the matter?
Leading case is Keshwananda Bharti versus State of Kerala.
Okay. Then what is offense for the
So,
Indian Penal Code?
as per Indian Penal Code, offense is uh, basically it is sir, as per Indian Penal Code, offense is basically the that is described as crime in the offense, where an act which is described as offense in the Penal Code, which is opposed in Indian Penal Code, and punishment has been prescribed for it. Exact section I'm not able to consider it. I think, sir, if I may try, it may be 41, sir.
Okay. What is zero FIR?
So, sir, it is a very new concept actually when we are considering about zero FIR. It is basically without having a particular jurisdiction or without getting into a particular police station, you can a person can file a zero FIR in the through phone, telephone, or it does not require the jurisdiction, the crime of the jurisdiction to be taken into that particular place. For example, in the case of Asaram Bapu case, the zero FIR was filed because the victim was residing in some other place, whereas the accused was some in a different place.
What is robbery?
So robbery is basically it defined in 393, where it is an aggravated form of extortion and theft, where basically a person is forced for in the fear of instant death, instant hurt, to do certain act which to do certain act or to extract some kind of property from that particular person.
What is inchoate crime?
Sir, inchoate crime is basically a crime which is of incomplete nature, sir, where basically the crime basically has four stages of it: intention, preparation, attempt, and commission. But in inchoate crime, basically the four aspects of it is not being covered. For example, conspiracy, abatement, these are some of the part where inchoate crime is being concerned.
What is mischief?
So mischief is mentioned in section 415 to 425, sir, where it is a wrongful loss caused to other party, but no wrongful gain is considered in this particular case, where you harm some other party, but you do not get any benefit out of it.
X entered into the land of Y in the middle and the dead hour of the night with intention to fell a tree and to commit theft of the tree.
Sorry, sir, I
X
couldn't hear you, sir.
X entered into the land of Y
Yes, sir.
in the dead hour of, in the into the land of Y in the dead hour of the night with an intention to cut a tree and to commit theft of the tree.
Right, sir.
X caught that tree. After hearing the falling sound of the tree, the owner came there. So X left the tree and fled out. What offense he committed?
Sir, X has committed the offense breaking inside the house or inside the property, that is trespass. Second, it has committed theft, because theft is something as described in section 378 of Indian Penal Code. It is basically where a person tries to move with a dishonest intention, that tries to move a particular movable property from one place to another, or as soon as it is severed from the ground, if the moment he has severed from the ground, it is to be considered that he has committed theft, sir.
Whether attempt to commit suicide is an offense. Attempt to commit suicide is an offense at present.
Sir, as per 309 of in Indian Penal Code, committing of suicide was an offense, but now it is declared as unconstitutional, sir.
Unconstitutional. Which court has declared?
Punishment for providing this 309 as punishment for providing 309. I don't think so. Now punishment is being provided, sir.
Okay. What is kidnapping?
Sir, kidnapping is basically, it is segregated into two parts. That is kidnapping of a person that is a minor. Secondly, kidnapping a person who is uh, who is to be taken outside of India. So when a particular person that is a minor is being taken away from the guardian, or the particular person, concerned person, the guardian person, the child is being taken away by enticing it, then the moment that particular child has been taken away from the custody of that particular child, it is to be considered as kidnapping. And another kidnapping is whenever a particular person is taken away from particular country, that is from India to any outside person, it is to be considered as kidnapping, sir. Outside place,
What
it
is
is to be considered as kidnapping.
what is abduction?
Sir, abduction is basically, it is not an offense itself, but it is combined with several other offense and several other part of abduction, where one person, a major person, is taken away from one place to another place without his wish, or without his intent to go with that particular person, sir.
What is dowry death?
Sir, Sir, dowry death is being defined. It is being given in IPC 304A, where basically a woman, if in the if if in the 7 years of marriage has died in a unnatural circumstances, it is considered as dowry debt. And previously, if that particular woman has been harassed for dowry, then in that case court will presume that a dowry death has been done.
What is estoppel?
Sir, estoppel is basically, it is generally given in section 115 of Indian Evidence Act, where estoppel from 115 to 117, where estoppel is basically where where a person says something, and as per that particular statement, if somebody another person did some act in forward of it, then it is no, then he cannot return back to his own words, or he cannot deny about that words. That is estoppel.
What is promissory estoppel?
Sir, promissory estoppel is basically in used in Contract Act, where a person is has said something. In the case of Abdul Aziz, also it is said that if a person has said something and upon that a particular act has been done, in order to consider it he's saying, then in that case it will be considered as promissory estoppel. He cannot get back, and he has to pay compensation for that, sir.
What is dying declaration?
Sir, dying declaration is being discussed, is being provided under Indian Evidence Act, Section 32, subsection 1, where if and while dying, a person claims something, or a person gives a statement something, after then that person dies, then after that this dying declaration becomes a evidentiary, becomes having a evidentiary value which can be used against the person.
How a handwriting of a their disputed handwriting is to be proved by the court?
Sir, as per Section 45 of Indian Evidence Act, in the expert witness, a handwriting expert will be called by the court itself to check about the handwriting, and his opinion, court, if court want, may consider his opinion for handwriting.
What is doctrine of lispendence?
Sir, doctrine of lispendence is given in section 52 of Transfer of Property Act, where lispendence is basically having a dispute in the property, and the matter is still in the court, and it is not being decided, and during that particular matter, during that particular time, the property cannot be disposed of without the court's order, sir.
What is mortgage?
Sir, mortgage is basically when a particular amount is taken in place of a particular property as a security, immovable property, basically immovable property as a security, then it is to be considered as mortgage. It is given in section 55, sir.
What is lease?
Sir, lease is basically providing, it is like a rent, but it is provided for a immovable property to enjoy its rights of whole property except the right of alienation or right of sale. It is given a property to enjoy for some consideration to a longer period of time, that is more than 1 year, and it is also to be registered under the government, under the rules and regulation that is provided by the government.
What is gift?
So gift is basically given in section 125 of Transfer of Property Act, where a particular person wants to provide another person, or wants to transfer a property to another person without any consideration with his own will, and for disposing that property he has his own voluntary will to let that person to enjoy and have the ownership of the property without consideration is gift, sir.
What is onerous gift?
Sir, onerous gift, basically, sir, I'm so sorry, I'm not able to recall this exact section, but onerous gift is the encumbrance added to that particular gift, where the person accepting that particular gift cannot deny the encumbrance attached to it or the liability attached to it.
What is actionable claim?
Sir, actionable claim is given in section 3 of Transfer of Property Act, where basically a actionable claim is a claim of money, a particular loan is given to other party without any security, sir.
X has reared fish in his tank. X has reared fish in his tank. The
Right,
fish is
sir.
in the tank. X reared fish in the tank. The fish of X is in the tank. Whether that fish is movable property or immovable property.
So sorry, sir, I couldn't get you. Please again.
If X has reared fish in his tank, the
Right,
fish
sir.
are in the tank. Whether that fish is movable property or immovable property.
Sir, rearing of fish or right to fishing is basically a immovable property, but
No,
fish
no.
as a
Hmm. I am not asking
fish
you,
is a
right of
movable
fishing
property.
is not there. Whether that fish is in the tank, whether that is a movable property or immovable property.
Sir, fish is a movable property, sir.
What is declaratory suit?
So, declaratory suit is basically given in section 34 to 36 of the Specific Relief Act, where it is the parties, it is the discretion of the parties, or it is a discussion of the parties that they wanted to get settled about some private nature, where they want to declare about the property, or they want to declare about the marriage. They can claim as of by filing a declarative suit, sir.
What is injunction?
So injunction is basically given in section 36 to 39 of the Specific Relief Act, and also it is mentioned in Order 39 of Code of Civil Procedure, sir, where it is being given that if any irreparable loss, or in the prima facie itself, it is found that a irreparable loss it will be there, then in that case a court can issue an injunction, where the other party will be barred to utilize the other property as its whims and fancies, sir.
What is the difference between injunction and writ?
Sir, injunction is basically filed when there is a irreparable loss, and it can be also in terms of filed in the court, that is lower court, but a writ can only be filed in the high court and supreme court, sir.
The personal law was your subject. The personal
Right,
law.
sir. Personal law was my subject.
What are the conditions in Hindu Marriage Act for a valid Hindu marriage?
Sir, as per Section 5 of Hindu Marriage Act, it is being given that the person should be major, they should have a sound mind, the parties who are of major nature should not be involved in a subpoena relationship or prohibitory degree, and also should be should be having the age criteria, should be major to have a marriage. And also they should form the customs, they should also perform the ceremonies in order to consider it as a marriage ceremony or registered marriage.
Registered marriage is required
Sir,
for
sir,
Hindu
sir,
marriage.
I mean usage, sir. Sir, I mean, sorry, usage or ceremony has to be performed, or a saptapadi has to be performed, sir.
Saptapadi is a must for every Hindu marriage.
No, sir. Saptapadi is one of the requirement, but it is not the only requirement. If there is certain ceremonies or usage is being given in the marriage, in the custom itself, then it can also be considered for marriage.
What is the difference between void and voidable marriage under the Hindu law?
Sir, voidable marriage means the annulment of marriage. That is, the marriage is not taken in at the first of it. It would be considered as void, or marriage is cancelled. We can say in a normal word. But when it comes to voidable marriage, the marriage will exist till the time at option of one of the parties the marriage is not called off, or marriage is not considered as void.
What is divorce by mutual consent?
Sir, divorce by mutual consent is given in section 13B, where both the parties, after residing together for 1 year, can file for mutual divorce that they want to get separated, and after a matter of 6 months, they will again be called for hearing, where if they are not able to reconcile, then they can claim for divorce.
Okay. Now let me give you some feedback on your interview
Right, sir.
because you are having a number of law degrees that you possess now a number of law degrees like LLM, etc.
Right, sir.
Okay, because your answer are coming like a layman.
Okay, sir. Okay, sir.
Let, what is the because some bare act terms must be there in your mind.
Right, sir.
Bare act terms. You cannot add something because you are facing an interview. You are a postgraduate degree holder. Some, but you know the concept, but you are unable to express because of lacking that is bare act language. That is the
Right,
whole
sir.
problem. What I found.
Yes, sir.
Doctrine of basic structure. I put a question. Yes, you are correct. That was that this doctrine of basic structure was for the first time ruled by the Supreme Court of India in the famous Baloknath case. Judicial review is also a basic structure that is decided in the Menoram case.
Oh, yes, 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 sir,
That
yes,
is
sir, yes, sir.
that should you put
Nirvam.
in mind because you are
Yes,
constitutional expert, constitution postgraduate degree.
yes, sir.
Then offense, and simply, my question, offense any act or omission punishable by law for the timing course.
Right, sir, right,
That
sir,
is
yes.
offense. You are not supposed to live like a layman. You are saying, give your answer is like that.
Yes, sir.
Any act or omission punishable law for the time in force or for
Yes,
which
sir.
a complaint can be filed under section 20 of the Card Trespass. That is
Right,
offense.
sir.
Then zero FR I will do. Yes, you are correct. Zero FR, your concept is also clear, but you are unable to express it properly. Zero FR means everybody knows that when an offense is committed at a particular place, the FR is to be lodged within the jurisdiction, within the police station under whose local jurisdiction that particular place comes.
Right,
So
sir.
zero FR can be filed even if that place of occurrence, place of commission of the offense does not come within the local jurisdiction of a police station. The police cannot refuse to entertain that FIR if disclose a cognizable offense. He will register it with a zero number and forward it to the particular police station having jurisdiction.
Right, sir. Right, sir.
That is the concept of jurisdiction. That is robbery. You are also committed a total wrong. Robbery, theft becomes robbery in certain circumstances. Extortion becomes robbery in certain circumstances. In every robbery, either there is a theft or an extortion. Theft becomes robbery when, at the time of committing theft or while carrying out the property taken by theft, the offender for that end causes any injury or wrongful restraint, that is robbery.
Right, sir. Right, sir. Yes.
Similarly, while committing extortion in a this fear of instant death is given, that is robbery.
Right, sir.
Probably that you know, but you are unable to explain. That is the whole problem. There's inchoate crime, incomplete crime. That's
Yes.
sufficient. Incomplete crime. There is incomplete crime is also certain cases punishable like conspiracy, etc. Conspiracy, that is attempt to commit the crime. This that is not attempt to, that is preparation for committing the crime. That is the best example of inchoate crime.
Yes, sir. Yes, sir.
Simply in the prepared state. Mischief you also committed a wrong. Mischief means whoever intentionally or knowingly causes any injury or damage to the property of the public or any other person.
Yes, sir.
Mischief.
Yes, sir.
When property damage, your car is parked, somebody puts a car. That is the
Yes, sir.
mischief.
Yes, sir.
Yes. That is trespass. Trespass you told me, yes, that is about yes. My question was X got the free. There, if in the same act, their movement takes place. Whoever dishonestly takes without the consent of that person takes any moving property from the possession. In the same act, if any movement takes place, so that is also theft because the illustration itself clears.
Yes, sir.
By that act, movement takes
Yes, sir.
place. By falling of that tree, some movement takes place.
Right,
The
sir.
concept is to clear. Kidnapping is of two kinds. One is kidnapping from lawful guardianship and kidnapping from India. Your
Yes, sir.
concept is only kidnapping of minor. No, if an innocent person, an idiot person, they can be
Yes.
kidnapped from the lawful
Yes, sir.
guardianship of somebody. Kidnapping who is taken or enticed from beyond India without his consent.
Yes,
That
sir.
is kidnapping from India. Abduction by force or deceitful means. You imitate. Whoever takes a person by force or deceitful means from one place to another, that is abduction. Now we were clear. Dowry death, again your concept, you know, but you are lacking the language to express. If a married woman dies within 7 years of marriage, otherwise than normal circumstances, and it is shown that soon before her death she was subject to cruelty for dowry, then that will be treated as dowry.
Yes, sir.
Married woman is there. Your woman dies, married
Um,
woman.
I agree, sir.
Yes. Estoppel, any act, omission or declaration. If a person by his act, declaration or omission made another two person to believe a thing to be true, and if on that belief that other person has acted upon, then in a suit between him and that person, he cannot deny the truth of this.
Right, sir.
You know, but you are lacking the language to express. That is the thing. Act only in civil suit. The principle of estoppel is a principle of revenge. You made somebody to believe a particular to be true, and on your belief somebody has acted upon, changed his position. Then in a
Right, sir.
suit you cannot deny the truth of this. Now you are clear.
Right, sir.
Then promissory estoppel is applicable only in most of the cases against the government. In the promise of the somebody has changed his position.
Right, sir.
Suppose the promissory estoppel, best example, government promised to give tax benefit or incentive if a particular industry is established. Somebody established the industry, they can stop theft. That is promissory estoppel.
Right, sir.
Then Gain declaration. Gain declaration is a statement given by a person regarding the cause of his death
Yes,
or
sir.
any of the transaction of the circumstances leading to his death.
Yes, sir. Sir,
Then,
actually, I couldn't figure out that particular word. I was just lacking. I was
yes,
trying
you
to
have to
figure out.
remember because you are a law graduate. You are not expressing like a layman. I cannot add something to the law, but the law are there. You have to remember
Exactly, sir. Yes, sir. Yes.
any statement regarding the cause of death or any of the
Yes, sir.
transaction regarding the circumstance leading to his death. That is admissible as a dying declaration when the death of that person is in question.
Yes,
In any
sir.
person.
Exactly.
Then handwriting, not calling expert. Handwriting is to be proved by sending that handwriting to the expert examination
Yes,
or
sir.
by examining a person who is acquainted with the handwriting of that person.
Right, sir. Right, sir.
Acquainted means who has seen that person writing or who has regularly received some document containing his handwriting. That
Right,
is
sir.
handwriting. This pendants, again you committed a mistake. When during pendency of a suit, if party cannot transfer so as to defeat the right of that person who will be passed in a decree in favor of that person. That is this pendant. First, the suit is pending in respect of a property. That property cannot be transferred without the permission of the court. So as to defeat a decree which will be passed against that
Yes, sir. Yes.
person.
I forgot. Okay.
Mortgage, mortgage is transfer of an interest. Always remember, an interest in
An interest.
specific amount property as security for payment of money.
Right, sir.
An interest, one that is layman point of answer. Then lease. Lease is a transfer of right to enjoy certain property for certain period in payment of rent, periodical payment.
Right, sir.
Lease is a transfer of right to enjoy certain properties, certain period. No
Yes.
registration is required for agriculture. Then gift. Gift is a voluntary transfer of property made by a person donor without consideration to the donee and the existing property. And the gift must be accepted by the donee during lifetime.
Right, sir.
That is gift. Honorous gift. When a gift property is gifted and there is a burden on the donee to discharge something, to do
Right, sir.
something, so that is honorous gift. Accidental claim. Any claim to any debt other than debt secured by mortgage or
Yes, sir.
hypothecation, the civil
Right,
code
sir.
grants as an action remedy. Then here fees also, here committed a blunder also. When benefit arising out of the land benefit arising out of the land, when a piece is there in the tank, that is a movable property. When a piece comes out, that becomes a movable.
Yes, sir.
That is movable. When the soul of piece is in the tank, that is immovable property.
Yes, sir. Yes, sir. But, sir, actually, I got confused because I said that right was immovable property.
No, right, I am not taking. Piece is there in the tank. What is the nature of property of the fish? Everybody knows fish is a movable property.
Right, sir. Right, sir. Right, sir. Yes, sir. I just missed it in just a little
Yes,
part.
declaratory suit also, you also answered in a layman point of as a layman. Whenever a person denies somebody's legal character, legal entitlement, status
Yes, sir.
of somebody, we can file a suit to declare such status, such right.
Right, sir.
That is declared. Injunction, injunction, irreparable loss, that is for temporary injunction.
Yes,
I'm
sir.
not putting an, my question of what is injunction? Injunction is an order of the code, civil code, directing a person to do or not to do something.
Okay. I'll
That
take
is
this.
it.
Yes, sir. Yes, sir. Yes, sir. I got this.
Difference between injunction and writ. Writ is a command. It is a command by the super, that is constitutional court, highest court of the country. That is High
Yes,
Court and Supreme Court. But in injunction is always issued by a civil court, never
yes,
by
sir.
High Court. You are correct, but your answer you should be very careful. Another mistake means make your answers brief and clear. More you say, more you trouble, you will invite some trouble.
Right, sir.
If you do not know a particular thing, sure, you may say, excuse me, sir, I do not know. But
Yes, sir.
I do not know. Because nobody is expert. I do not know everything also. Nobody is expected to know everything on this earth, where the law is such a vast subject. Your personality testing. And
Yes, sir.
so far as your self-introduction is concerned, you minimize it. And so also, I'm from Rautala, my education qualifications. More questions are asked like that. Sometimes it is also as briefly, shortly, right? As your performance, you know, you simply You lack the language to express. That is, where act language must be remembered. Either as a judge, as a law student, as a law lecturer, certainly. Theft it is to be theft. Not any other thing. Who takes the property, that will not be theft.
Right.
Okay? Thank you. I wish you success.
Just a small request, sir. As per today's interview, how much would I score if it is of 100 marks?
No, mark is immaterial. Mark is immaterial. Be confident. You try to give your answer properly. Yes, mark is something that differs from person to person.
Okay.
Because that is giving a mark differs from person to person.
Right, sir. Right, sir.
Unfortunately, in the Odisha, as you see, different. A same person, one person doesn't remain throughout all the interview.
Right, sir. Right,
Previously, when I was appearing for the examination, one judge was conducting the entire interview.
right, sir.
So what will be a mark that differs from judge to judge?
Right, sir. Right, sir.
Anyone?
Sir, was
Okay.
my performance satisfactory, sir?
Yes, everything is satisfactory, but that must be with some brief language and this
Okay.
proper language, and not as a layman.
Right, sir.
Okay.
I'll work hard on this, sir. I
Right.
definitely work
Okay.
hard.
Work. Thank.
Thank you,
Okay.
sir. Thank you very much.
Okay.